question is for the Attorney-General, and I ask it in the capacity that the Attorney-General is responsible for the implementation of the Royal Commission's recommendations. When the National Redress Scheme began following the Royal Commission, it was far from faultless, and I compare it to the infamous Melbourne response run by George Pell, where survivors are asked to sign a deed of release, which stops them from suing the institution down the track. I understand that this was to limit civil lawsuits, but it only seeks to benefit the institution who inflicted the suffering. Some survivors are seeing other survivors of the same perpetrator receive compensation through the courts and wondering why they can't now do the same. Others may not have been mentally ready to go down that path, but may well be right now. They also may not have the evidence at the time of the redress claim, but they may now have that and are ready to proceed. Attorney, will the state government lobby your federal colleagues to have the deeds of release removed from the National Redress Scheme claims?
Attorney-General.
Thank you, President. I thank Mr Grimley for his question. And of course, there are many redress schemes that fall into either direct responsibility of me as Attorney-General or I have responsibility for establish them, but might be in someone else's portfolio, such as forced adoption, as you would be aware of. Yeah. In Victoria, all of our state-run redress schemes do not have a limitation on people's ability to seek other avenues such as civil claim, presumptive rights and the like. You are correct, the federal redress scheme has a limitation. I wasn't involved at the time of the establishment of that redress scheme. However, I would be it was subject to a lot of negotiations with all the states, all of the relevant organisations and bodies to come up with a redress scheme that was for the benefit of people that were subjected to sexual abuse in institutions. That redress scheme is subject to review. They're looking at the eligibility and the like, and as my role, I contribute to meetings that are conducted across the Commonwealth and state jurisdictions. There is a working group that the bureaucrats are involved in, for example, and it is always our intention to listen to victim survivors and bring their stories and their experiences, lived experiences, whether it be through their experience in accessing redress or their concerns about how there may be some barriers that they're experiencing in accessing that scheme. So issues such as you've raised, there are multiple opportunities for those to be brought to the table, and at the next meeting these are the types of topics that are discussed, and as I said, there is a current review in relation to the stage 2 process of that redress scheme that's looking at eligibility, and these are the issues that can be canvassed in that forum. But as you have identified, it is not a direct responsibility that I hold. Your question asks whether I will lobby. I think it's probably more appropriate for me to raise it at the appropriate time.
Mr Grimley on a supplementary.
Thank you, Attorney. Thank you, President. And you pretty much covered everything, I think, for the supplementary, but I'll raise it regardless because I think it's important. So if you receive a VOCAT payout as a victim of crime, you're able to sue the perpetrator. If you sue successfully, you have to return your VOCAT money clearly, otherwise it's double dipping. Interestingly, there are instances where you can sue and then get redress, which is another story. Some survivors will never have the money for lawyers or the energy to fight legal battles, so redress is all they desired, but other survivors may decide down the track that they are ready to sue for whatever reason. It seems like we've got a bit of a double standard, like you mentioned, in Victoria for victims of crime and so forth, but the National Redress Scheme does not allow for sexual abuse survivors to go down the path of a civil litigation. Attorney, if the deeds of release are to remain, what plans does the government have to fix this issue and ensure that victims of sexual abuse are not silenced and have access to civil litigation procedures?
Mr Grimley, and probably the only information that I didn't canvass in my response to your substantive question would be the changes that we made here in Victoria, and I think 2019, around restrictions that were placed on people under a deed. We made sure that Victorian courts would have the power to set aside deeds of settlement for sexual cases against the state. So there are, as you've identified, very few limitations in relation to people seeking legal redress as opposed to state-based redress schemes, or legal compensation, probably more appropriate, in Victoria, and that's the position that we hold. The federal system has that barrier, but you can clearly see Victoria's government's position on Victorian-run redress schemes.
Thank you.